Good afternoon, Prime Minister. My name is Eva Krajewska, and I'm Councillor for the Canadian Civil Liberties Association. Prime Minister, I wanted to start off with the quick chronology leading up to the invocation of the Emergencies Act. On February 13th, you meet with the IRG around 4 p.m., correct?
Yes.
And then you meet with Cabinet the evening of the 13th, correct?
Yes.
And at that time, Cabinet delegates to you the ultimate decision to invoke the Emergencies Act, and Clerk Charette characterized this as left it at referendum to the Prime Minister, correct?
Yes.
And you consult with your caucus the morning of the 14th, correct?
Yes.
And then with the First Ministers the morning of...
Sorry, it was more of an informing caucus than consulting with them, but yes.
Okay. That's fine. And then you consult with the First Ministers also the morning of the 14th.
Yes.
You speak to Mr. Jagmeet Singh and the Leader of the Opposition, Ms. Bergen, that same day. And you announce the invocation of the EA at a 4:30 press conference that afternoon, correct?
Yes.
Correct. And so the Emergencies Act is invoked on February 14th. And then the measures that are put in place under the Emergencies Act are enacted on February 15th, correct?
Yes.
And those, if I can put them as two buckets, the two buckets of measures that are invoked on the 15th, the first are there is now a prohibition on public assembly that may lead to a breach of the peace, correct? Mm-hmm. And the second are various economic measures that include the freezing of accounts of anyone who is involved in that public assembly that may lead to a breach of the peace, correct?
Yes.
Right. And now going back a little bit, you spoke briefly about Windsor. The blockade at the Ambassador Bridge, that was a significant event. That was one of the events that led to the invocation of the Emergencies Act, correct?
It was one of many, but yes.
It was one of many. And you understand that the police, both the Windsor Police Service and the OPP, started to clear that block starting on February 12th?
Yes.
And that continued on February 13th?
Yes. And
I believe WPS, Windsor Police Service, tweeted that the Windsor Ambassador Bridge was cleared at 1200 on February 14th.
That sounds right.
Now, with respect to Coutts, that was another blockade of a border that was causing you and the government a significant concern, correct?
Yes.
And you were informed by Premier Kenney on February 14th in the morning that the RCMP had started to make arrests the night before, correct?
Yes.
And that, in his words, the situation has been secured, and they will now proceed with broader arrests and secure the border. You remember that?
Yes.
Okay. And in Alberta is one of the provinces that had in place or has in place a critical infrastructure legislation that protects critical infrastructure from blockades, including highways, correct?
Yes.
Now, the Ottawa demonstrations in the blockade, they don't get removed until later in the week of February 15th, correct?
Correct.
And for the purpose of that operation, the RCMP, the OPP, and the OPS, they form a joint command.
Yes.
And Prime Minister, you agree that the Emergencies Act and the orders enacted under the Emergencies Act, there was nothing in those orders that created the joint command.
No.
Right.
Sorry. Yes, I agree that the Emergencies Act did not address creation of joint commands, although it did allow for the easy deputization of RCMP officers to enforce municipal bylaws and municipal rules without having to go through the usual processes that are required if they want to do that, which allowed for a greater integration.
Correct. It did away with the administrative process that was taking some time of having the RCMP enforce local bylaws.
So it did facilitate the coming together of those three forces.
But the joint command in and of itself, that was something that the police could have created and could have done without the invocation of the Emergencies Act.
Yes.
Right. And we heard evidence from Commissioner Lucky of the RCMP that she had signed off on a plan to enforce and remove the protesters in Ottawa on February 13th, that she had confidence in, that she, the OPP, and the OPS had confidence in. Did you hear that testimony?
No, I disagree with that.
Okay, you disagree with that?
Yes, I do not believe that the plan that was either signed off on supposedly by the RCMP or presented by the Ottawa Police Services on the 13th was in any real regards an actual plan for clearing the protests.
And is this a plan that you saw, or that you were just spoken to about?
I was spoken to about. I did not see it myself.
Okay, and were you spoken to about it by Commissioner Lucky or by Minister Mendocino?
I don't remember.
You don't remember. But as at February 13th, your impression was that the plan that was in place at that time was not one that you or the RCMP had confidence in.
It was not one that we had confidence in, no.
Okay. All right. I will leave it there because I think there are other parties here that understand that better than I do. Okay. So in terms of the legal tools that were available in Ottawa, we heard evidence from Superintendent Bernier, who was the event commander for the Ottawa Police Services. You're familiar with that?
Yes.
Okay. He testified that he did not communicate to anyone that he needed, or the OPS needed, additional tools in order to implement their plan. Did you hear that evidence?
In hindsight, yes, during this process.
During this process. But at the time, you did not hear from OPS or Superintendent Bernier that the OPS required additional legal tools or legal resources.
What we saw consistently was the occupation was continuing, and the ability of the police to resolve it was not there.
Right, and you spoke about that earlier with Ms. Chowdhury, that both you, the government, and I think both Clerk Charette and Deputy Clerk Drouin all expressed the view that or even frustration that the police had not been using the legal tools available to them to remove the demonstrators.
Or had not been able to use.
Or had not been able to use those
legal
tools.
Yes.
Okay. And Prime Minister Brenda Lucki, the commissioner of the RCMP, also on the 13th, she was of the view that existing legal tools had not been exhausted, and she communicated this to the Chief of Staff to Minister Mendocino. Were you aware of that?
I was not aware of that at the time. As we went around the virtual table at the IRG that day, the consensus from everyone, including the Commissioner of the RCMP, was clear that we were advancing on these extra tools. And as I said, I don't disagree with that assessment that not all tools had been used. That was part of the problem, that not all tools were being used to end this occupation.
Right. And Prime Minister, we talked about the threshold for invoking a national emergency. You spoke about that briefly in your examination in chief. And you understand that other than the threshold in the CSIS Act, part of the test is whether the matter exceeds both the capacity and the authority of a province to deal with the matter. You understand that?
Yes.
And Deputy Clerk Drouin said that authority refers to legal authority and capacity refers to operational capacity. And you would agree with that?
Okay, yes.
And when I'm taking you back now to your press conference at 4:30 on the 14th. At that press conference, you specifically referred to the fact that there were serious challenges to law enforcement's ability to effectively enforce the law. You remember that?
Yes.
And that the Emergencies Act will be used to strengthen and support law enforcement agencies at all levels of the country. You remember saying that?
Yes.
And that the police will be given more tools to restore order in places where public assemblies can constitute illegal and dangerous activities.
Yes.
And so at that time, that was one of the main justifications that you stated publicly for the invocation of the Emergencies Act.
Yes.
And that was, again, because many of your ministers and many of the people in the public service had expressed frustration with the police inability to exercise those legal tools.
No, it wasn't just because people had expressed frustration. It was real concern. As you mentioned, that a number of places were moving in the right direction in terms of resolving the situation at Coots, resolving the situation at the Ambassador Bridge. There was a very real and present concern that it is one thing to clear a lane or two, it is another thing to keep a border location or otherwise open. And what we had seen was intentions for the convoy to pop up again at the Blue Water Bridge in Sarnia. At Fort Erie, there was discussion of Lacol. There were more activities starting in Surrey and BC at other border crossings. There was a ongoing concern that it wasn't just about ending the places that were there. It was ensuring that they simply didn't shift to another locale, because many of these convoy participants had come a long way across the country and were mobile enough to go to another nearby location.
And so you were in a sense making sure it was almost preventative in terms of we've removed them and we want to prevent them from relocating and restaging at another location. Would that be fair?
Yes, that was a concern, but at the same time, there was very much a concern that it be temporary that we brought in, that we not keep the Emergencies Act in place for a minute longer than necessary. And when the RCMP suggested that they wanted it in place for 3 weeks, or they would need it in place for up to 3 weeks, we took that very seriously as a request, but we ended up saying, no, we're going to end it as quickly as we can, and we did.
And Prime Minister, you spoke about how you were advised that it would be impermissible for the government to direct the police, and that was a line that you and your staff and your ministers understood very clearly, correct?
Yes, we were very careful about that.
You're very careful about that.
Yes.
But you'd agree that when you invoke the Emergencies Act and you very publicly say to the police, these are tools that you now have, that you are publicly signaling, this is the road we want you to walk down now and use these tools in order to deal with these demonstrators. Do you agree with that?
We were very clearly saying that we need to restore enforcement of the law and we need to restore public order. But as I said clearly a little earlier, in the situation of a theoretical blockade at Lacol, I was very clear with the Premier of Quebec and indeed in communications that if the public order emergency tools weren't necessary, they didn't need to use them.
And Quebec did not invoke their own Emergencies Act, correct? They did not.
I'm not sure, but I'll take your word for it.
Well, I don't think Quebec invoked their Emergencies Act for the purpose of the thing, for the convoy. Now, my last area of question, Prime Minister, is with respect to the CSIS Act and its integration into the Emergencies Act. So you've stated under the CSIS Act, when CSIS determines that they are going to use surveillance on a person, they need to meet the threshold at Section 2, correct?
Yes.
And that's because the surveillance of one person without other legal authority is something that is very serious and that requires a high legal threshold, correct?
Yes.
Now, I understand your evidence that for the purpose of the Emergencies Act, we are dealing with a different context, yes?
Yes.
A different purpose?
Yes.
And we're dealing with a different decision maker, correct? But I would put to you that when invoking the Emergencies Act, that threshold, the level of threshold of the security threat that must be met cannot be any lower than it is when CSIS is proposing to surveil one person, that the threshold is no different. Do you agree with that?
Yes, I do.
Thank you, Prime Minister. Those are my questions.
Okay, next is the Canadian Constitution Foundation.
Commissioner, my friend has asked to switch spots.
I see that.
We've advised the parties. Yes, I am not Mr. Kittredge, and no parties have objected, so.
Okay, well, in the spirit of cooperation, that's fine with me.
Thank you, sir.
And have you given up your time on the Canadian Constitution?
Oh no, not at all.
Okay, just want to be clear.
I know hope springs eternal, but I'm afraid not.
Okay.
Yeah.
All right. Well, good morning, Mr. Prime Minister. I'd like to quickly circle back.
Could you
Oh, I'm sorry.
particularly
Mr.
given
Prime Minister.
my mistake?
I'm Rob Kittredge for the Justice Center for Constitutional Freedoms, and we share standing at these hearings with the Democracy Fund and Citizens for Freedom. I'd like to circle back to a bit of a constitutional conversation I had the other day. Cabinet confidentiality, the principle that members of Cabinet are free to express their opinions on issues before Cabinet fully in private meetings and discussions with you and their Cabinet colleagues. Are you familiar with that principle?
Yes, I am.
And the principle of Cabinet solidarity, where once decisions are presented to the public or to Parliament, they are collective decisions of the Cabinet and can't be repudiated or criticized by your ministers. And if they were to do that, they would have to resign their post.
That is a principle, yes.
All right. Tow trucks have come up a lot at this commission, and my friends and the commissioner know me by now as a bit of a towing aficionado. It's been a while since I've brought up the subject, but I thought maybe you and I could have a little talk about it. As you know, in order to legitimately and legally declare a public order emergency pursuant to the Emergencies Act, the purported emergency cannot be effectively dealt with under any other law of Canada. You're taking the position that the emergency declaration was justified in part because towing services were required and could not be procured. Is that accurate?
That's a bit of a leap. We say that the Emergencies Act was required because the situation as a whole could not be resolved under existing authorities and was not being resolved under existing authorities.
Right, but towing service procurement was part of that total picture that you're talking about, wasn't it?
One of the barriers that we heard regularly from police of jurisdiction to removing the trucks occupying various locations was the difficulty in securing towing services. Yes, that was one of the barriers they were facing in being able to restore public order.
Right. So one of the measures that you put in place through the emergency measures regulations was an ability to compel tow truck drivers to provide towing services, wasn't it?
Yes, it was.
So I'd say that would be a fairly significant part of the reason why you would have had to invoke the Emergencies Act. Wouldn't you agree with that?
It was an element of the solutions to the situation that we were dealing with. Yes.
It was one of a handful of powers that you created using the emergency measures regulations. Is that right?
Yes.
So I would say it's relatively important. Would you agree with that?
It was important in yes, solving the emergency situation. Yes.
Certainly relevant to the invocation of the Emergencies Act?
The invocation of the Emergencies Act wasn't because people couldn't find tow trucks. The invocation was because there was a public order emergency that posed serious threats to Canadians, and the inability to solve this public order emergency that posed a serious threat to the safety of Canadians was compounded by the inability to actually move those trucks, for example.
And that would be one of the ways that the emergency couldn't have been effectively dealt with under any other law of Canada, wouldn't you say?
Municipalities and provinces have contracts with tow truck companies to keep the highways clear, to keep the roads clear, and tow parked cars that are illegally parked all the time. So they had theoretically the authority to compel people under breach of contract to actually tow vehicles that were illegally parked.
for various reasons, they were unable or unwilling to use the civil powers they have under contract, or perhaps it would just take too long for them to be able to do it. But in feedback with everyone from Alberta to Ontario to elsewhere, was that they needed to be able to compel those tow trucks to actually do the job of clearing those streets.
And you, in fact, put that power into the emergency measures regulation.
Yes, we did.
And so a discussion of that, of tow trucks, is relevant to this discussion we're having right now.
Yes.
We talked about cabinet solidarity earlier. There's been a waiver of cabinet confidence, the related, partial waiver, I should say, of cabinet confidence, the related principle that would have allowed you to withhold documents from this commission. You've disclosed quite a few, and would you say you've been pretty transparent with the commission?
There have been hundreds of public inquiries over the course of our country's history, and only 4 times were there waivers of cabinet confidence. For this situation, it was extremely important to me that all the inputs, or as many inputs as possible, that cabinet received in making the determinations that we did, are visible to Canadians. So yes, we've waived cabinet confidence in terms of the inputs that cabinet heard to make the decision, but the actual deliberations, as you point out, remain secret.
Great. So you wanted to make sure that the relevant matters were visible to Canadians. Can I pull up POE JCF 2, please? So this is a document as it's coming up. We've been having a bit of an argument over the last little while about some redactions that were made in the documents disclosed by my Friends for Canada. And there were some disputes about parliamentary privilege and irrelevance. But in this particular document, I'd like you to take a look at this. This first document was what was originally disclosed. And this document, the second one, had some redactions removed and those documents were ordered disclosed last night, Canada took the position last night that there was reason to insist on this redaction, or that this document not be produced unredacted. But I wonder if maybe you could, and at the end of the day, this was produced at 10:26 a.m. this morning, so I'm a little more unprepared for this cross than I normally am. But I wonder if you could look at that first redaction on the original disclosure and see if you can see the reason for the redaction that's highlighted in the black box there.
It appears to say irrelevant and parliamentary privilege.
Right, so I'm looking at the irrelevant one. Could you identify on the other side what information was blacked out as irrelevant by your government?
Americans offering tow trucks.
Yeah, and wouldn't you say that discussion of tow trucks was relevant to the discussion we're having here today?
I'm not the one who made these redactions. It's the professional public service that made those redactions, so you'd have to ask them. Right,
well, I think we will be. But in any event, I would put it to you that tow trucks weren't in fact required, that the power to compel tow trucks was not used for anything other than convenience, and that tow trucks had been secured at all important locations prior to the invocation of the Emergencies Act. And I got to say, it's interesting to close on this tow truck point. I hadn't expected that to happen. But would you agree with me that tow trucks weren't in fact needed at the time of the invocation of the Act?
Mr. Commissioner, Brian Gover for the Government of Canada. And if my friend is going to put that to the witness, he ought to put the proposition correctly. I remind my friend that the evidence of Commissioner Carrick of the Ontario Provincial Police was that the powers under the Emergency Measures Regulation in relation to tow trucks were used. I refer specifically to his February 22nd, 2022 report to Deputy Solicitor General Di Tommaso, which shows that clearly those powers were used. Thank you.
Right. Well, I would respond by saying that the evidence so far has shown that while strictly speaking there was an invocation of, or there was a use of that power under the Act by the OPP, it was basically used as a method to ensure that the payment was made.
It's It's
any
supposed to
event.
come to me, and I think those happen to be areas that I'm going to have to deal with,
enough.
what is in fact the case. But you can pose your question in a different way if you wish, but I think whether or not they were used, whether or not it was required is something I will rule on.
I think we're bearing the lead a little bit here, and I'll ask you again. You would agree that a discussion of tow trucks and information about tow trucks is relevant to the work of the commission and the discussion that we're having here today, wouldn't you?
I know there was a lot of time spent on tow trucks during the past 6 weeks.
Right. Well, thank you very much.
Okay. Thank you. Next is now the Canadian Constitution Foundation, or have I? Yes. It is? Okay. Thank you. I don't want to get it wrong again.
It's been a long 6 weeks, Commissioner. Good morning, Prime Minister. My name is Sujit Chaudhary. I'm counsel for the CCF. Prime Minister, I'd like to shift gears a bit and ask you some questions about your role as chair of the cabinet. And so it's true, would you agree, that one of your chief responsibilities as Prime Minister is to chair the cabinet?
Yes.
And it's a serious responsibility.
Yes.
And so yesterday, there was a panel testifying from the Prime Minister's office, I'm sure you're aware. And your Chief of Staff, Katie Telford, answered questions about your role as chair of the cabinet. Are you aware of her testimony?
Yes.
Okay. And so she, under cross-examination, she testified that you are the ultimate decision maker for determining the information and documentation shared at cabinet meetings. Do you have any reason to disagree with what she said?
Yeah, that was in a series of questions, linked to, who ultimately decides who's in the room or not. The reality is the authority rests with me. If I, in seeing what the public service has prepared for me as a list of subjects at cabinet or attendees at cabinet or documents to be provided at cabinet, if I have significant issue with any one of them, I can say, no, we're not going to present that to cabinet, and it won't go to cabinet. But as par for the course, I do not spend time going over in advance every possible document going to cabinet to say, yes, this can go, this shouldn't go, this can't go. It's in exceptional circumstances.
So there's advice provided to you by the Privy Council office? Is that what you're saying on what documentation and information goes to cabinet? It's presented to you for review and then you sign off on it, yes or no?
No. For example, if we're dealing in cabinet with a particular MC from, or a particular proposal from a given department, they will put forward that document, that proposal. I will, as par for the course as all cabinet members do, read through that documentation as part of our deliberations that we're about to have. But for me, I have the power to say, no, you know what, we're not going to discuss this today, or this document's not going to go in, which I do from time to time. If we decide, no, it's not ready to go forward, we're not going to do that. But I guess I'm not entirely sure what power you're trying to get me to admit to having or not having.
Sure. So, well, why don't we talk about the February 13th cabinet meeting? So the questions are about that. And so you'd agree, sir, that that was an extraordinarily important cabinet meeting?
Yes.
A historic meeting, even?
Yes.
And though, even though it was happening at a time of great pressure, of great urgency, you would have taken care to determine in your capacity as chair of cabinet that cabinet had all the relevant information and documentation before it.
The way cabinet works is we do an awful lot of work in cabinet committees. We do not, as a par for a course, dig into every item that comes forward in a fulsome way because we have subgroups of cabinet that dig into that. So there will have been, before any cabinet meeting, including that one, subgroupings meeting to debate, to discuss things that then get reported back to cabinet.
But you would agree that under the Emergencies Act, as you stated this morning in testimony, the power to declare a public order emergency rests with what you called the cabinet and prime minister, which is the governor
and council.
Right, which is the full cabinet, not a cabinet subcommittee.
No, that's right.
Okay.
Cabinet subcommittees deliberate, but as a matter of generality, they don't make final determinations.
And you agree, there's no way you could have declared a public order emergency without having a full cabinet meeting.
In this case, it was something very important to me. I could imagine catastrophic scenarios in which a government might have to declare a public order emergency without a meeting of full cabinet, either because of urgency or because of circumstance that prevents cabinet from gathering.
But in this case, there was such a meeting.
Yes, in this case, I chose to have a meeting.
So I'd like to ask you some questions of what you've termed as the inputs to that meeting. And just to be abundantly clear to my friend from the Attorney General of Canada, I'm not going to ask you about the content of any of those inputs that might be protected by confidence. I just simply want to ask you if certain documents were inputs or not to the cabinet meeting, if I may. So the first is that we've heard in testimony that there was a legal opinion that explained the difference in the definition of threats to the security of Canada in the CSIS Act and the Emergencies Act, and you've testified to that this morning. Do you know, sir, if that a legal opinion was provided to the full cabinet at its meeting of February 13th?
In matters of legal opinion, in many situations, most situations, we hear from the Attorney General and Justice Minister who reports to cabinet on this or that legal opinion.
So was that written opinion provided to the cabinet, sir?
I believe it was a report from, a verbal report from the Minister of Justice.
Okay. I'd like to ask you about another document, which is that we've heard about a threat assessment prepared by CSIS, and you're familiar with that as well. And Director Vigneault testified that he'd concluded, or CSIS had concluded, that there wasn't a threat to national security under 2C of the CSIS Act. He also testified that that threat assessment was provided to the IRG on February 13th. So my question is, was this threat assessment provided to the full cabinet on the evening of February 13th?
In our reporting to cabinet, there was a reporting on the consensus reached by the IRG, including the director of CSIS, who recommended and agreed with the invocation of a public order emergency. We were not at cabinet dealing with whether or not CSIS had the authority to move forward with a wiretap on one person or another. It was a discussion on the invocation of a public order emergency, which requires reasonable grounds for the governor and council to make a determination.
So, sir, you'd agree that that document was not provided to the full cabinet on February 13th? You said a report.
Which document is that?
The CSIS threat assessment. And if I could rephrase what you said, you just said the IRG considered that report, it discussed it?
No. Throughout the IRGs, CSIS, as a par for a course, would mention that the threshold had not been met for CSIS operations within this of a particular type, according to their context and their mandate. But we were not looking as an IRG or a cabinet as to whether or not CSIS would be allowed to do this or that thing. We were looking at, certainly by this end, whether or not we had a threshold met for the invocation of a public order emergency.
So Prime Minister, Director Vigneault testified that a written threat assessment was prepared by CSIS, and he testified that he provided that to the IRG.
Yes.
Are you saying that that document was not provided to the IRG?
No, that would have been provided to the IRG.
But would you agree that it wasn't provided to the full cabinet?
Yes, I agree that it was, that the report was given, that that the narrow CSIS threshold was not met for a CSIS operation, but because that was not the issue at play in this cabinet discussion. The issue was the threat of serious violence threshold met in the context of a public order emergency, was the discussion at play.
And Prime Minister, this morning in your testimony, you addressed the policing plan that was prepared by the OPS, and I believe you stated we should read it, we should look at it, because it wasn't much of a plan. Is that fair?
That is my understanding of it.
So,
yes.
Sir, I'd like to pull the plan up on the screen, please. And Mr. Registrar, it's PB NSC CAN 407734. Thank you, Mr. Registrar. Prime Minister, is this the document or is this the plan you're referring to?
I have not, I have heard about this. I haven't ever actually seen it. So,
sir, what I'd like to do, so you've not read this?
No, I have not.
Okay, so
I certainly had not read it on the 13th.
Okay, and so I'd like to just, Mr. Registrar, I'd just like to walk the Prime Minister through the pages, not so he could read it because we don't have time, but just to point out that this is a heavily redacted document. So page 1 is the cover page. Page 2 is this signature page. If we could go down, page 3 is a description of the situation and the mission. And then, Mr. Registrar, if you could please scroll down. The rest of this document has been redacted. So that's page 4, page 5, page 6, page 7, page 8. So, Prime Minister, you said we should read this plan. We can't. It's within your legal authority to instruct your counsel to remove these redactions. For the sake of the transparency of this commission, sir, would you consider that request?
I object to that. On behalf of the Government of Canada, it's Brian Gover once again. This is putting the Prime Minister in an odious position. We had no notice that they would attempt this in cross-examination. These things require careful consideration, do not lend themselves to decisions in the moment, and we maintain our objection.
Commissioner, sorry, sir. This was in our document list that we circulated within time to counsel for the Attorney General. They had noticed that we would be putting this document. And the question is a fair one in response to the Prime Minister's testimony this morning that he said you should read it.
I think it is fair in a sense, but I think what's being raised is it's a little more complicated than the federal government or the Prime Minister releasing these. This is a police operational plan of the OPS involving officers from the OPS and from OPP involving strategy, et cetera. And I would be very surprised if the federal government would order its release without consulting with the various police services. And I think that's the unfairness that's being referred to. And quite frankly, I agree. Now, having said that, he made reference to the plan, and there is an issue about reading it for sure, but I think the context is important here.
So, Commissioner, with that, with your ruling there, and I thank Mr. Gover for his point, Prime Minister, can I put it to you this way? You said we should read the plan, but I think you would agree we can't.
Indeed. As I said, I haven't read the plan, but we're in a situation where, as can be imagined, I have access to unredacted information, and what I know and my understanding of this plan was, and I'm happy to testify to that, that it was not a complete plan of engagement.
And Prime Minister, and again, I think I would like to raise this again. I'm looking to Mr. Gover in anticipation of his reaction. As you know, there's a legal opinion that over which solicitor-client privilege has been asserted. We asked Minister Lametti to release that opinion, and in a public statement this week, he said he couldn't because he lacked the authority to. That would be up to his client, and he then clarified that his client is the governor and council. So again, for the record, sir, and this has been an issue for all week, not just this morning, would you advise that that opinion be released in the interest of transparency?
Mr. Commissioner, it's Brian Gover once again for the Government of Canada. Solicitor-client privilege, of course, is a very substantial right in our legal system. It's one that the Supreme Court of Canada has recognized has a constitutional dimension. I remind my friends that in this case, as the Prime Minister has said, cabinet confidence has been waived for the 4th time in 155 years to provide evidence of inputs. We know that the decision note that was referred to in testimony by the Clerk of the Privy Council referred to the advice of the public service that it was appropriate to invoke the Emergencies Act. In my submission, we need not go further with the inquiry and pierce the veil of solicitor-client privilege, setting what in my submission could be a dangerous precedent going forward. And this is certainly an issue that requires careful consideration and not one to require a Prime Minister to respond to in the spur of the moment. Thank you.
Okay, well, I think you have a refusal essentially by council, so I think you're going to have to move on.
Okay, thank you, Commissioner. And so I have one final question, sir. So there has been a lot of discussion this week about legal thresholds and how they differ under the Emergencies Act on your government submission than they do under the CSIS Act. And you testified about this morning. I just want to ask you one question. The emergency was revoked on February 23rd, correct?
Yes.
We can take my word for it. And prior to that revocation, there was a great deal of public debate and public discussion about the case for the emergency made by the government. Is that right?
Yes.
And sir, I'd put it to you that not until this commission has the government of Canada ever publicly communicated that the threshold for determining a threat to national security is different under the Emergencies Act than under the CSIS Act. Not once. Why is that, sir?
It's in the first line of the public order emergency section of the Emergencies Act that the governor and council can, on reasonable grounds, declare a public order emergency if, in their reasonable opinion, I'm paraphrasing obviously, there are threats to the security of Canada and it is a national emergency. That doesn't mention CSIS threshold anywhere.
Commissioner, I think those conclude my questions. Thank you.
Okay, thank you. Just before I go to the next cross-examiner, there seems to be some reactions in the crowd that, in my view, are inappropriate. This is I think, a very important process and very serious. There are a lot of people outside, as I understand it, who would like to come in. I would ask you to please refrain from comments or laughing or whatever, and try and keep it serious. That would be appreciated. And not only appreciated, if necessary, it will be enforced. So could I ask that you continue to be attentive and pay the attention that is required for what's going on. So with that brief comment, call on the Ottawa Police Service, please.
Good afternoon, Prime Minister. My name is Jessica Barrell, and I am counsel for the Ottawa Police Service. Prime Minister, we've heard evidence from you about your understanding of intelligence information as well as operational planning at various points throughout the events in Ottawa. And I just want to clarify your role as it relates to that information. And I take it it's not your role as Prime Minister to collect intelligence information. Is that correct?
No, it's not.
Similarly, it's not your role to review the details of an operational plan.
No, it's certainly not.
And that's because you rely on highly trained police officers to perform the work that they're best at, which is performing those functions, and then it gets briefed up to you. Is that fair?
Yes.
And I assume that you regularly rely in particular on the intelligence and operational planning expertise of the RCMP as they are the National Police Service, correct?
Yes.
And of course, you trust them to perform those functions effectively.
Yes.
Okay. So we've heard considerable evidence to date from the Commission that an integrated planning cell arrived in Ottawa on February 8th. Were you aware of that?
That sounds right.
And we also heard that Superintendent Bernier from Ottawa Police Service took over as event commander on February 10th and established what he referred to as an integrated command structure, which we heard described from him as including experts from subject matter areas such as negotiations, public order, intelligence, et cetera. Were you aware of that?
That sounds reasonable, yes.
Okay. And the experts involved in both the integrated planning cell and the ultimate integrated command structure included senior and specially trained officers from OPS, RCMP, OPP, and other municipal police services. Would you agree with that?
Yes, I was aware of that.
And as you indicated, you would have, of course, leave it up to those experts to draft, review, and approve operational plans. Is that fair?
Yes.
Okay. And you certainly wouldn't have had the capacity in your role to engage in any kind of line-by-line review or assessment of the viability of those operational plans.
No.
Okay. And so I want to focus, because we've heard a fair bit of evidence about this morning, in relation to the timeframe of February 12th onwards and the operational plans that existed at that time. You participated in an IRG meeting on February 12th, is that correct?
Yes.
Okay.
Yes.
And so I'd like to pull up the minutes from that meeting if we can. It's SSM NSC CAN 214, please. And in particular, I'm looking for page 6, Mr. Clerk. And so we see in the second paragraph that this is an update from the Minister of Public Safety, and we see the last sentence of that. During the discussion, confirmation was obtained that the OPS Chief of Police accepted the plan and the Commissioner of the RCMP agreed to be able to provide additional details of that plan at the next call. Do you recall that?
I'm looking at the sentence before where it says there appears to be a lack of a plan in Ottawa, with the Chief of Ottawa Police Services having yet to approve the plan developed with the RCMP and OPP.
Right, and then subsequent to that, we see that in the middle of the meeting, there's confirmation that the OPS chief has agreed to the plan and that Commissioner Lucky agrees to provide additional details to this group subsequently in relation to the details. Is that fair?
Fair.
Okay. And so this was put to Commissioner Lucky in her testimony, and my understanding of her evidence is that she never did subsequently provide the details of that plan to this group on the 13th or otherwise. Would you disagree with that evidence?
No, I agree, because what we heard was the plans were not adequate. They were not operational plans at that point.
Okay, but you didn't ever hear the details of the plan. And she certainly doesn't say in this meeting that from her perspective, it was not an adequate plan. She's just saying, I'll provide you an update later.
I can't speak to what she was knowing or not, but I can say that when we were briefed on the 13th as to the operational plan or readiness of enforcement in Ottawa, we were understanding that there was not a full operational plan at that point.
Okay, so your understanding of what occurred on the 13th was that you were provided some level of information that led you to believe that there was no complete operational plan. Is that fair?
That was consistent with everything we heard throughout the course of the 3 weeks, that there were not yet concrete plans to be able to actually do the work that Canadians were hoping to see.
Right, so I understand that there are various planning timeframes, but I'm specifically talking about the 13th and whether you were provided details of a complete operational plan to end the protests in Ottawa.
my understanding was there was not a complete operational plan to end the protests in Ottawa as of the 13th.
Okay. I'd like to bring up OPP 1851, please. Okay, so let's just start with the title page. This is called Integrated Mobilization Operational Plan. And if we could scroll down to page 2, you can see at the top that the plan was written by the Integrated Planning Cell that has multiple services listed there. It's dated the 13th. And we see that there's sign off here from Superintendent Phil Liu of the RCMP, Chief Superintendent Carson Party of the OPP, and Acting Superintendent Rob Bernier of the Ottawa Police Service. You see that? Okay, and so I just want to, if you look at the bottom of this, the screenshot here, you can see that this is a 73-page document. You see that?
Okay.
Okay, and so obviously we don't have time, unfortunately, to fully digest this entire document. But is it fair to say that prior to the police operation on February 18th to 20th, as well as prior to the invocation of the Emergencies Act, you had never seen this document?
No.
Okay.
Sorry, no, yes, it is fair to say that no, I had never seen it.
Thank you for that clarification. And so you suggested multiple times in your evidence this morning that to your knowledge, the operational plan that existed at the time of February 13th was by no means an actual plan to actually end the protests in Ottawa. Is that a fair representation of your evidence?
That was my understanding, yes.
Okay. And you also testified that it was not a plan that you or the RCMP had confidence in. Is that correct? At least that was your understanding.
If there wasn't a plan, then we probably didn't have confidence in it.
Fair enough. But as you can see here, there is a 73-page document dated February 13th that a senior member of the RCMP has signed off on. Correct?
Yes.
Okay. So if we just scroll down, as I said, we don't have time to review the entire document, but we do have a table of contents here. And so I just want to go through a few components of the parts, or component parts of the overall plan so that you understand kind of the general scope of it. And so if we scroll down a little bit, we see there's a deployment plan, right? A reference to a deployment plan.
Sorry, the entire deployment plan is on page 13.
Yes, so I'm just trying to understand the scope of the plan. Since I only have 10 minutes, we can't actually digest the entirety of the plan. So you can see that there's some content in relation to deployment plan.
Sorry, is this a table of contents?
Yes.
So the entire deployment plan fits onto one page?
Well, a description of the deployment plan is, okay. And then we see a reference to investigative plan. Correct.
I can't speak to whether this is a good plan or a complete plan or not. I haven't read this, obviously.
Right, and so you hadn't read it, obviously,
No,
then.
I rely on the inputs of the experts around me to reassure me or not that there is a capacity to move forward.
Okay, so let's turn to page 8. And we see the objectives listed, if we could scroll down. And it says to facilitate a resolution through de-escalation, graduated, measurable, and multi-phased response while ensuring the safety of participants, citizen, and members of participating agencies, and return the city of Ottawa to a state of normality. And so you referenced earlier in relation to the plan that from your understanding, all it was to continue the negotiations essentially that were already taking place, correct?
Listen, I am hesitant to speak to fragments, but I don't know that objective 1 looks like the enforcement action that actually happened later that week.
Okay, well, I can
If they
tell
talk about a de-escalation, graduated, measurable, and multi-phased response, sounds like something that would take longer than the 24 to 48 hours that the enforcement action actually took on Friday and Saturday. But I'm no expert on this, so my lawyers are probably glaring at me for opining on this too much.
Fair enough. Well, I can tell you that the experts on the plan have testified, and they have testified that this was the plan that they were acting on the weekend of February 18th when they completed the POU operation. Would you have any reason to disagree with that?
I think evaluating various testimonies is the job of the commissioner.
Fair enough. Okay. And I just want to pull up.
You're pretty close. Well, not pretty close. You're over the end. So if you can try and wrap it up, please.
Thank you. And so to circle back to the comments you provided in relation to the readiness of police plans as of the 13th, I take it you would agree with me that perhaps there was a little bit more substance to the plans than you were aware of on the 13th.
I am unable to speak to that.
Okay. And we've heard evidence that the Ottawa Police were required to acquire approximately 2,200 additional police officers from across the country to support this plan and to successfully complete the POU operation that occurred on the weekend of February 18th. Would you have any reason to disagree with that?
I wasn't aware of, I wasn't following that presentation of evidence, so I can't comment on that.
Fair enough. And you may have heard or not, that this was the largest POU operation in Canadian history. Were you aware of
That I was aware of.
Okay, thank you very much for your time. Those are my questions.
Okay, well, thank you. This is a little early, 2 minutes early. We don't normally give an hour and 2 minutes for lunch, but I think today we will as a special occasion.
Thank you for your generosity.
So we'll come back at 2 o'clock.
The commission is in recess until